when you're looking at challenging a vocational expert, first, my hope always is that I'm going to get a vocational expert who agrees with me, and frankly, many do. I tried a case with one particular judge, and he asked his hypothetical, and he framed the hypothetical that he thought the answer was going to be, yes, he can work, and the answer was, no, he can't work. And Mr. Cole, do you have any questions? Well, no, sir. I was fine with that. Well, lo and behold, we didn't get a decision. We got a supplemental hearing with a new vocational expert and a new medical expert. He didn't like what anybody had to say. And they brought the new vocational expert, and the new one did get whiff of the way the wind was blowing and said, oh, yes, Judge, you're correct. He can't work, or he can work, rather. That case was a denial and was reversed because it was clear it was simply a shopping expedition to bring those in. But if you do have a vocational expert who is who's given a decision which is negative to you, make sure you look at a couple things. Have they correctly defined past relevant work? Is it really past relevant work? Did they work that job long enough to make it a job? If somebody has a failed work effort, they got hired somewhere to do a job and they worked that for 30, 60, 90 days, that's not past relevant work. They never did that job long enough to show they could perform that job on a regular basis. Did they make enough income that that job was actually a job? Substantial gainful activity. Particularly, I find, and I'm sure Mark and Krista and you in your practice find that most claimants are not, as they're often portrayed, they're not people trying to beat the system. They're those who tried and changed jobs and done different things. And so many of them have tried other jobs. And so you want to look at whether that was a valid work effort. Did they actually acquire any skills? Because they may have been there just long enough to get fired. And that's not really a past relevant work. I had a hearing recently where a gentleman had worked, didn't finish high school, didn't have a GED, had worked in construction, and then suffered an injury, which was severe, and then got a workers' comp settlement and used that to try to go to culinary school, try and work as a cook. He figured that's got to be easier than what I was doing. He did that job long enough that it became past relevant work. But if he hadn't been able to do that for a period of time, then I would have argued he didn't acquire those skills. That really wasn't something he looked at. Again, where does that come into play? At step 4 of the process, where they're looking to say whether he can do past relevant work. Make sure your vocational expert has accurately described the past relevant work they did, and that the work they're talking about is indeed past relevant work. Also review the resume or CV of the vocational expert. We had an expert who on the CV appeared to indicate that their degree was from the University of Illinois. Their main campus is in Champaign-Urbana, but was off at another campus. Well, on inquiry, and that's the good and bad news of Google, is that it will let you find a lot of information out, some of which is wrong, some of which is correct. But that wasn't part of the University of Illinois system. The particular school that he was citing, and every state has those, they'll take some school and then you'll have a variety of online classes or sign them up and we'll grant you a degree mills, which are close in sound to the legitimate school. So it wasn't the University of Illinois as we knew that. It was actually, turned out it was Illinois University of Chicago, which was not what had been portrayed. So make sure you've checked the resume of your vocational and medical experts.
I actually have a similar story. There was a vocational expert that referred to himself as doctor. Everyone referred to this person as doctor. He did have a PhD, but I believe it was in history that had absolutely nothing to do with his vocational background. And that was something that local attorneys kind of chuckled at, to say, when he refers to himself as doctor and how he introduces himself, if necessary, you can slide that little piece of information in there.
Right. And I think it does a couple things. Krista's point is well taken. First, to a law judge, it indicates that you're well prepared. And to the witness, it indicates you're well prepared. And a lot of times you'll get them to back off a tenuous position if they know that they're going to be examined. And so if you've taken the time to look into that and inquire, then maybe they're not going to quite feel that they can speak with impunity on anything they want to. So in addition to looking at their CV or resume, making sure they correctly describe the past relevant work, where does the vocational expert get their numbers? They're looking at the DOT in terms of job descriptions. They will usually come up with the numbers for those jobs based upon either some old census data or a variety of other tools they use, and sometimes they'll simply cite their own experience.
Yeah, and it's important that you can ask them, where did you get this information from? And when they pull out the yellowed piece of notebook paper that they've been using in the hearing for the last 20 years, it is important to say, well, when's the last time Mr. or Mrs. So-and-so that you updated that? And some of them, they don't really have a real great answer for that. And then I find that a lot of times if you kind of put them back on their heels a little bit, and I'm not saying go after vocational experts to be mean or things like that, but if they know that you're really wanting to make sure that they have all their I's dotted and T's crossed, I find that sometimes they give you a little bit more on your questions.
Right, and it's like any expert, or many experts, if they think they have unfettered reign to say whatever they want to, and you don't know anything about it, and you're going to yield the floor to them all the time, sometimes it just gets going away. And particularly if you get a difficult judge who wants to frame the hypotheticals,